Fraudulent Conveyances and Creditors' Bills. Chapter I. Introductory Observations. Growth of the Law Concerning Fraudulent Conveyances. Phases of the subject. SS1. Severity of the Roman Law. Modern changes. It has been truly observed that the protection and preservation of the rights of creditors must be a fundamental policy of all enlightened nations. The method by which this protection may be extended and rendered practically effectual is, however, a problem very difficult of solution. The barbarous practice which prevailed among the ancient Romans of putting an insolvent to death, or selling him into slavery, pictures to our imaginations the strong legal and moral foundation which a pecuniary obligation had in the minds of the people in early times. The penalty for the failure to pay a debt was as severe as that which is now ordinarily imposed upon criminals for the commission of the most heinous of crimes. The chains which held a debtor in the power of his creditor have one by one been broken, but the sacredness of a promise to pay a debt, notwithstanding the abrogation of the ancient penalties, is still voluntarily cherished by the mass of mankind. Yet, unfortunately, the protection and preservation of the rights of creditors is often the last consideration with a numerous class of careless or dishonest insolvents. Satisfied of utter inability to pay maturing debts, their remaining property is frequently diverted to inequitable purposes or squandered with reckless profusion. The confiding creditor, when driven to the necessity of seeking a discovery of equitable assets, often finds at the end of the litigation nothing but a mass of worthless securities or a beggarly account of empty boxes. The underlying reasons for this deplorable condition of affairs will be briefly considered. SS2. Prevalence of fraudulent transfers. The cause. Since the general abolition of imprisonment for contract debts, dishonest people have grown bolder and more reckless, and the power of creditors to enforce payment of just obligations has been correspondingly diminished. This humane reform in our law, which was inspired by the desire to relieve honest but unfortunate debtors from the painful consequences formerly incident to insolvency, is now eagerly availed of by unscrupulous people who contract obligations with little expectation and no probability of fulfilling them. Abolition of imprisonment for debt removed the chief barrier and preventive of fraudulent conveyances, viz., the terror of the debtor's prison. The personal liberty of the debtor being no longer at stake, the natural tendency has been to promote reckless and extravagant expenditures, and to encourage and foster wild business speculations. The cost of every reform must be borne by some person or class of persons, and creditors are at the present time paying the great price exacted by this radical change in remedies. The collection of a debt by ordinary process of execution against property on a judgment is now comparatively a rare occurrence. Hence we have in our modern jurisprudence a perplexing problem with which our forefathers were little vexed, i.e., the question how to neutralize or avoid, in favor of creditors, colorable or covenant transfers of property, which this violent change in remedies has rendered it difficult, if not impossible, to prevent or suppress. Collusive voluntary conveyances and secret fraudulent trusts and reservations of 1,000 dies, calculated to hinder and defraud creditors, are the constant and daily subject of investigation in our courts. The temptation of debtors who have not the skill to acquire property honestly, or who have been overwhelmed by some unavoidable disaster, to enrich themselves at the expense of their creditors by some transaction wearing a deep complexion of fraud, seems to be irresistible. This is especially the case in a country such as ours, where the comforts and delights which accumulated property brings are so accessible and well guarded, and in which the acquisition of wealth may be regarded as a profound passion. It may be possible to pity the infirmity of the human mind, sinking under an approaching pressure of distress, and resorting to fraudulent means of protection and provision for a family, but the law cannot approve or sanction such transactions. Probably the most severe trial to which an honest man can be subjected is the inability to pay his debts, even by the application of all his means. He is assailed by temptations of interest, of pride, of shame, of affection, to wander from the straight line of duty and integrity, while at the same time he is entrusted by the law with dominion over property which equitably and justly should be devoted to his creditors. The quantity of litigation engendered by fraudulent conveyances is appalling, and the cunning devices and intricate schemes resorted to by debtors to elude the vigilance of creditors would, if no moral turpitude was involved, challenge admiration. The condition of the body of our law upon this subject is far from satisfactory, and may be said to still be in a formative and unsettled state. SS3. Scope of the inquiry. It will be the purpose of the first portion of this treatise to elucidate the principles of law affecting conveyances made in fraud of creditors, both in this country and in England, and to point out, somewhat at length, the practical methods by which such collusive trusts can be successfully unraveled, the property regained for creditors, and the prevalent modern tendency of debtors to hinder, delay, and defraud their creditors correspondingly repressed. Bills filed to reach equitable assets, not subject to execution, will necessarily receive incidental consideration. The power of a creditor to inflict anything in the nature of a punishment upon his debtor being practically abrogated in civil procedure, his right to a thorough and searching investigation as to transfers of the debtor's property, in the disposition of which the creditor may justly claim to have an equitable interest, at least to the extent of his demand, should manifestly be facilitated. Such, we are happy to notice, is the general modern tendency of the law, and one of the aims of this treatise will be to show the need of a still further enlargement of these facilities. The practical details of procedure in this class of litigation will receive particular attention. The rights of bona fide purchasers and grantees of debtors for valuable consideration will necessarily be embraced in the discussion. SS4. Forms of relief. It may be observed that the general purpose of creditors' actions is twofold. First, to reach assets, such as choses in action, which by their intrinsic nature cannot be taken on execution at law. And second, to recover property, whether tangible or intangible, which has been fraudulently alienated by the debtor. In the one case, the creditor comes into court to obtain satisfaction of his debt out of the property of the defendant, which cannot be reached by execution at law. In the other case, he proceeds for the purpose of removing some obstructions fraudulently or inequitably interposed to prevent a sale on execution. It is believed that as to the first class of cases, the jurisdiction of equity in favor of creditors was created to supplement the imperfect relief given by execution. SS5. Onus as to fraud, suspicions insufficient, absence of presumptions. The great obstacles to the effective development of the branch of our law under consideration are the natural tendency of the courts not to presume fraud in the absence of substantial proof of it, and the extreme difficulty attendant upon showing that a transaction, fair and perfect on its face, and having every semblance of validity, the guilty participants in which are often the chief witnesses in subsequent judicial inquiries, is in fact vicious and colorable. Then there exists in some quarters an unconscious sympathy with or for debtors whose fraudulent acts and transactions bear the imprints of intellectual acuteness. The clever or brilliant scoundrel too often escapes with his ill-gotten gains in the maze of admiration excited by his audacity. Fraud, it is also argued, will not be lightly imputed and cannot be established by circumstances of mere suspicion. Irregularities and carelessness sufficient to arouse a suspicion do not supply the place of proof of fraud. It will not be presumed where an instrument admits of an opposite construction. The common law, it is said, is tender of presuming fraud from circumstances, and expects that it be manifest or plainly inferable. Courts will attribute errors to mistake rather than to fraud, and will not base conclusions of fraud upon mistaken expressions of opinion. A dishonest purpose should not be presumed. Again, it is vaguely asserted that fraud is a fact which must be proved. Courts will not strive to force conclusions of fraud. There must be something more than mere speculative inference. And if the party charging fraud does no more than create an equilibrium, he fails to make out his case. As we shall presently see, it is not enough to create a suspicion of wrong. The creditor must prove tangible facts from which a legitimate inference of a fraudulent intent can be drawn. The evidence must convince the understanding that the transaction was entered into for a purpose prohibited by law. Hence, a court will not presume fraud and undue influence merely from the fact that the conveyance is made by a sister to a brother, nor from circumstances which merely indicate unusual generosity. Finch, J., in delivering the opinion of the New York Court of Appeals, said, "Fraud is to be proved and not presumed." It is seldom, however, that it can be directly proved, and usually is a deduction from other facts which naturally and logically indicate its existence. Such facts, nevertheless, must be of a character to warrant the inference. It is not enough that they are ambiguous, and just as consistent with innocence as with guilt. They must not be, when taken together and aggregated, when interlinked and put in proper relation to each other, consistent with an honest intent. If they are, the proof of fraud is wanting. Daniels, J., said in Marsh v. Falker, in all actions for deceit the presumption is in favor of innocence, and on that account the intent or design to deceive the plaintiff must be affirmatively made out by evidence. SS 6. The badges and evidences of fraud will be discussed presently. We may here observe that mere inadequacy of consideration, unless extremely gross, does not per se prove fraud. The disparity as to consideration must be so glaring as to satisfy the court that the conveyance was not made in good faith. Neither can fraud be presumed unless the circumstances on which such presumption is founded are so strong and pregnant that no other reasonable conclusion can be drawn from them. And it seems that even strong presumptive circumstances of fraud will not always outweigh positive testimony against it, nor will fraud be inferred from an act which does not necessarily import it, if an honest motive can be imputed equally as well as a corrupt one. The former should be preferred. Good faith in business transactions is a settled presumption of law, and the burden of proof is on the party who assails good faith and legality. Many an important case has been wrecked at the trial, or abandoned by the creditor, on account of the great embarrassments which this formidable onus imposed. This presumption is the creditor's stumbling block on the one hand, and the shield of unscrupulous debtors on the other. The creditor is constantly forced to carry the war into the enemy's country, and to take by storm the fortifications which the fraudulent debtor or his allies have carefully constructed to impede or repel the attack. It is said in Nicol v. Crittenden that it is impossible for a transfer to be in fraud of creditors unless it is made with a fraudulent intent, and that the nature of the intent will not be presumed as matter of law, but is to be inferred by the jury from the facts and evidence. This broad statement of the principle is at least debatable and will be considered presently. Then in Cummins v. Hurlbut, it was asserted that to set aside a written instrument on the ground of fraud, the evidence of the fraud must be clear, precise, and indisputable. A jury should not be permitted to find fraud to impeach a settlement in writing on any fancied equity, or on vague, slight, or uncertain evidence, even though they might think it fairly and fully satisfied them. As a general rule, the transaction which is the subject of attack has been evidenced in writing, and the cases show that a deliberate deed or writing, or a judgment of a court, is of too much solemnity to be brushed away by loose and inconclusive evidence. Fraud, on the other hand, is rarely perpetrated openly and in broad daylight. It is committed in secret and privately, and is usually shrouded in mystery and hedged in and surrounded by all the guards which can be invoked to prevent discovery and exposure. Its operations are invariably circuitous and difficult of detection. The proof of it is very seldom positive and direct, but, as we shall presently see, is dependent upon very many little circumstances and conclusions to be drawn from the general aspects of the case. SS 7. Judge Black's views. The learned Chief Justice Black urged that the proposition that fraud could never be presumed, but must be proved, could be admitted only in a qualified and very limited sense. The idea that it was a fundamental maxim of the law, incapable of modification, and open to no exception, was denied, and the principle was said to have scarcely extent enough to give it the dignity of a general rule. This vigorous writer observes, it amounts but to this, that a contract, honest and lawful on its face, must be treated as such until it is shown to be otherwise by evidence of some kind, either positive or circumstantial. It is not true that fraud can never be presumed. Presumptions are of two kinds, legal and natural. Allegations of fraud are sometimes supported by one and sometimes by the other, and are seldom, almost never, sustained by that direct and plenary proof which excludes all presumption. A sale of chattels without delivery, or a conveyance of land without consideration, is conclusively presumed to be fraudulent as against creditors, not only without proof of any dishonest intent, but in opposition to the most convincing evidence that the motives and objects of the parties were fair. This is an example of fraud established by mere presumption of law. A natural presumption is the deduction of one fact from another. For instance, a person deeply indebted and on the eve of bankruptcy makes over his property to a near relative, who is known not to have the means of paying for it. From these facts, a jury may infer the fact of a fraudulent intent to hinder and delay creditors. A presumption of fraud is thus created, which the party who denies it must repel by clear evidence, or else stand convicted. When creditors are about to be cheated, it is very uncommon for the perpetrators to proclaim their purpose and call in witnesses to see it done. A resort to presumptive evidence, therefore, becomes absolutely necessary to protect the rights of honest men from this, as from other invasions. The statement that fraud will not be presumed must be accepted understandingly, for it certainly can be inferred from facts and circumstances, and it is considered to be error to charge a jury that they cannot predicate fraud upon inference or implication, or that the proof must be irresistible, or clear and undoubted, or that it must be established beyond a reasonable doubt. For evidence that satisfies the mind will support a conclusion of fraud, although it may not lead to a conviction of absolute certainty. SS8. Proof of moral turpitude. The authorities have been multiplying, in certain quarters at least, to strengthen the efforts of creditors to overcome this difficulty arising from the presumption of validity and good faith. Many of the cases attach but little importance to the sworn assertion of perfect good faith and entire honesty on the part of the purchaser or of the seller, and the courts are trying to unravel these transfers without exacting explicit proof of moral turpitude. The intent or intention is regarded as an emotion of the mind, shown by acts and declarations, and, as acts speak louder than words, if a party is guilty of an act which defrauds another, his declaration that he did not by the act intend to defraud is weighed down by the evidence of his own act. A person would not be likely to accomplish an act and afterwards say that it was prompted by corrupt motives. The moral sense is much weaker in some men than in others, and it would be a strange rule which made one man's rights dependent upon another's moral sense. There are certain rules founded in experience and established by law for determining the validity of transfers under the statutes concerning fraudulent conveyances, and a transgression of these rules will justify courts and juries in avoiding the transaction without regard to the opinions of the parties to it, and their evidence should have little weight. In French v. French, Lord Chancellor Cranworth remarked, "I shall not say that the transfer was voluntary or fraudulent, but simply void as against the creditors of William French." Again he observed in Spackman v. Evans, "I do not attribute moral fraud to the appellant, but the whole transaction was fictitious." So in Backhouse v. Jett, Chief Justice Marshall said, "The policy of the law very properly declares this gift void as to creditors, but looking at the probable views of the parties at the time, there appears to be no moral turpitude in it." This principle may be further illustrated from Gardner Bank v. Wheaton, where the courts say, "When we pronounce the transaction between the defendants in respect to the conveyance from Gleason to Cole as fraudulent, we do not mean to insinuate that there was any moral turpitude on the part of Prince, nor do we believe there was any. But though the motives of a party may be good in such a transaction, still, where the design, if sanctioned, would defeat or delay creditors, neither law nor equity can sanction the proceeding, and on that account it is termed a legal fraud, or a fraud upon the law. It was not necessary, said Dwight C. and Cole v. Tyler, that there should be any actual fraudulent intent. The requisite intent may be inferred from the circumstances of the case. The act may be adjudged covenants, although the parties deny all intention of committing a fraud, and it is not necessary to impute to the parties a premeditated or wicked intention to destroy or injure the interests of others. And a man may commit a fraud without believing it to be a fraud. The statute, 13 Eliz, refers to a legal and not a moral intent. That is, not a moral intent as contradistinguished from a legal intent. It supposes that everyone is capable of perceiving what is wrong, and, therefore, if he does that which is forbidden, intending to do it, he will not be allowed to say that he did not intend to do a prohibited act. A man's moral perceptions may be so perverted as to imagine an act to be fair and honest which the law justly pronounces fraudulent and corrupt. It is not important what motives may have animated the parties, if the necessary effect of the disposition is to hinder and delay creditors. It results that the mental operation or emotion of the debtor and the legal conclusion from the acts and circumstances may be diametrically opposed. SS9. Fraud in fact and fraud in law. Some of the cases maintain that there is not, for any practical purpose, so far as the validity of the particular transaction may be concerned, any difference between fraud in fact and fraud in law, between a fraud proved by direct evidence and a fraud inferred by law from facts which are consistent with the absence of an actual intent to defraud. Whenever the effect of a particular transaction with a debtor is to hinder, delay, or defraud creditors, the law infers the intent, though there may be no direct evidence of a corrupt or dishonorable motive. But on the contrary, an actual honest motive existed. The law interposes and declares that every man is presumed to intend the natural and necessary consequences of his acts, and the courts must presume the intention to exist when the prohibited consequences must necessarily follow from the act, and will not listen to an argument against it. Hence it has been remarked that where a conveyance by its terms operates to hinder, delay, or defraud creditors, the intent to do so is imputed to the parties, and no evidence of intention can change that presumption. A different intent cannot be shown and made out by the reception of parole testimony, nor deduced from surrounding circumstances. What is meant by these cases is that whether the fraudulent intent is reasoned out and declared by the court by the proper application of the rules of legal construction and interpretation to the particular transaction or instrument under consideration, or whether it is found by a jury to exist as matter of fact. In either case, the transfer is made with the intent to defraud creditors, and may be avoided. Hence it is said that where the fraudulent intent is not apparent on the face of the deed, it is a question of fact for the jury, and the court has not the power to infer the intent. SS 10. The case is considered. This subject may perhaps be illustrated from the case of Harmon v. Hoskins, where it is laid down that the intent may be vicious. Though the deed is fair and regular upon its face, and a full price was paid, the intent must then be proved aliened. In cases where the transaction on its face is fair, if it sprung from the motive to hinder, delay, or defraud creditors, then the intent is purely a question of fact to be established by the testimony. But a party will be held as intending the natural and inevitable legal effects of his acts. Hence, if his deed by its recitals necessarily operates to interpose unreasonable hindrance and delay to creditors, or to entirely defeat their claims, the question of intent will be practically a conclusion of law. A deliberate act which naturally and inevitably produces a certain result must in law be held to have been contrived and performed to carry out and consummate that result. The court in such a case arrives at the conclusion, by a proper construction of the instrument, that such is its direct and inevitable effect, and its result, as matter of law, that the statute is satisfied. In other words, the transaction itself so palpably and conclusively establishes the intent that testimony upon that point would be superfluous, and a finding of a jury of an intent different from that which the legitimate construction of the instrument furnishes would be erroneous. Thus in Young v. Hinderance, a conveyance by a debtor of all his property, real and personal, without consideration, and in trust for the grantor's benefit during his life, and after his death for the payment of his debts, was declared to be fraudulent per se, no evidence alien being deemed necessary to establish the fraudulent intent. Proof of the intention to enter into the prohibited transaction is all that is requisite. When the courts declare an instrument fraudulent on its face, it does not necessarily mean that it was the offspring of a corrupt intent considered as a mental operation, but that it is an instrument the law will not sanction or give effect to, as to third persons, on account of its susceptibility of abuse and the great danger of such contracts being used for dishonest purposes. It may scarcely be proper to say in these cases that there is a presumption or conclusion of law that the transaction is fraudulent, but rather that the circumstances of the transaction, or the transaction itself, furnish conclusive evidence of fraud. And if, against such evidence, a jury, a judge, or referee should find that there was no fraud, a new trial would be granted, not because any legal presumption or conclusion had been violated, but because the finding was against the weight of evidence. Against conclusive evidence, the intent is gathered from the instrument, and no external aid is necessary to develop it. The fraud is self-evident, but to find fraud as matter of law, it must so expressly and plainly appear in the instrument as to be incapable of explanation by evidence de horse. Grover, J., an able judicial officer and vigorous writer, ignored the distinction between fraud in law and fraud in fact in these words: a distinction is attempted in some of the cases between fraud in law and fraud in fact. I think there is no solid foundation for it. When upon the face of the assignment any illegal provision is found, the presumption at once conclusively arises that such a legal object furnished one of the motives for making the assignment, and is upon this ground adjudged fraudulent and void. The result is the same when the illegal design is established by other evidence. The inquiry is as to the intention of the assignor. Coleman v. Burr is an extreme illustration. The referee found that the conveyance was honest, but the transaction was set aside because from the facts found the inference of fraud was inevitable. Fraud, said Mr. Justice Buller in Estwick v. Kellogg, is sometimes a question of law, sometimes a question of fact, and sometimes a mixed question of law and of fact. Perhaps it would be more accurate to say that fraud is never purely a question of law, nor exclusively a question of fact, though it frequently partakes more largely of the one quality than of the other. Fraud is not to be considered as turning solely on intent as an emotion, but as a legal deduction. What intent, said Ruffin, J., is in law fraudulent, the court must inform the jury, else the law can have no rule upon the doctrine of fraud, and every case must create its own law. Perhaps the clearest division of fraud is into three classes. First, fraud that is self-evident, with which the jury have nothing to do. Second, fraud which depends upon a variety of circumstances usually connected with motive. And intent, which is an open question of fact for the jury, with instructions as to what constitutes fraud. Third, presumptive fraud where the presumption may be rebutted. SS 11. Words hinder, delay, or defraud. To hinder and delay creditors is to do something which is an attempt to defraud, rather than the successful accomplishment of a fraud, to put some obstacle in the path, or interpose unjustifiably some period of time before the creditor can reach his debtor's property, and apply it toward the liquidation of the debt. The words hinder, delay, and defraud are not synonymous. A conveyance may be made with intent to hinder or delay without an intent to absolutely defraud. Either intent is sufficient. The statute is in the disjunctive and attempts to attach a separate and specific meaning to each of the words which it employs. An instance of hindrance and delay within the statute is given in a case in Pennsylvania, where a debtor departed from the state leaving no property subject to the process of his creditor, and making no provision for the payment of his debts. A better illustration is to be found in a case in the New York Court of Appeals, where the debtor conveyed his property in trust for his own benefit during his life, and after his death for the payment of his debts. The authorities avoiding assignments by the terms of which the assignee is empowered to sell upon credit are, perhaps, more in point than either of the illustrations given. A conveyance of real estate by a debtor upon the understanding that the grantee should hold it in trust for the grantor, and as fast as money could be realized therefrom, should apply it to the payment of his debts, necessarily operates to hinder and delay credit a debtor's property, is in theory of law subject to immediate process issued at the instance of his creditors, and the debtor will not be permitted to hinder or delay them by any device which leads it, or the avails of it, subject to his control and disposition, and it makes no difference that the debtor intends to apply the avails of it to the payment of his debts. So a deed of trust creating a lien upon personalty for an indefinite period, the natural operation of which is to benefit the grantor, is fraudulent as to creditors. The statute seems to be aimed at three things which it is supposed insolvents would possibly be tempted to do for the purpose of avoiding or deferring the payment of their debts. First, they might dispose of their property in such manner as to interpose obstacles to legal process, with intent to hinder creditors in the collection of their demands, or, second, to delay payment to some future period, or, third, to defraud their creditors by absolutely defeating all attempts to enforce their claims. Any one of these purposes is sufficient to avoid the transaction. If the design of a transfer is a lawful one, it matters not that a creditor is thereby deprived of property which might otherwise have been reached and applied to the payment of his debt. Hence it is that a general assignment, or a preference, is upheld, though each is often made or given to thwart some belligerent creditor. The secret motives that prompt the act in such cases are unimportant. Speaking of devices to aid the debtor, Davis, J., said in Robinson v. Elliott, the creditor must take care in making his contract that it does not contain provisions of no advantage to him, but which benefit the debtor, and were designed to do so, and are injurious to other creditors. The law will not sanction a proceeding of this kind. It will not allow the creditor to make use of his debt for any other purpose than his own indemnity. If he goes beyond this, and puts into the contract stipulations which have the effect to shield the property of his debtor, so that creditors are delayed in the collection of their debts, a court of equity will not lend its aid to enforce the contract. A debtor cannot take the law into his own hands and attempt to secure the delay which can only be obtained by the consent of creditors. SS 12. Word disposed construed. In Bullion v. Smith, it appeared that Section 398 of the Revised Statutes of Missouri authorized an attachment to issue in the following, among other cases, where the defendant had fraudulently conveyed or assigned his property so as to hinder or delay his creditors, where the defendant had fraudulently concealed, removed, or disposed of his property or effects so as to hinder his creditors. The court held that the word disposed, as here used, covered all such alienations of property as might be made in ways not otherwise pointed out in the statute. For example, pledges, gifts, pawns, bailments, and other transfers and alienations which might be effected by mere delivery and without the use of any writing, assignment, or conveyance. Other species of conveyances were excluded. Hence, it was held that a charge to a jury to the effect that the defendant had fraudulently disposed of his property was not supported by proof that he had executed a fraudulent mortgage. SS 13. No definition of fraud. Fraud is as difficult to define as it is easy to perceive. Courts of equity have skillfully avoided giving a precise and satisfactory definition of it. So various is its form and color. It is sometimes said to consist of any kind of artifice employed by one person to deceive another, conduct that operates prejudicially on the rights of others, or withdraws the property of a debtor from the reach of creditors. But the term is one that admits of no positive definition, and cannot be controlled in its application by fixed and rigid rules. Fraud is so subtle in its nature, and so protean in its disguises, as to render it almost impossible to give a definition which fraud would not find means to evade. It is to be inferred or not according to the special circumstances of every case. Whenever it occurs, it usually vitiates the transaction tainted by it. Fraud cuts down everything. Fraud, said de Grey, C.J., is an extrinsic, collateral act, which vitiates the most solemn proceedings of courts of justice. Lord Coke says it avoids all judicial acts, ecclesiastical or temporal. It is the judgment of law on facts and intents. Its existence is often a presumption of law from admitted or established facts, irrespective of motive and too strong to be rebutted. Fraud, said Story Stowe, J.J., will vitiate any, even the most solemn transactions, and an asserted title to property, founded upon it, is utterly void. Fraud is always a question of fact with reference to the intention of the grantor. Where there is no fraud, there is no infirmity in the deed. Every case depends upon its circumstances and is to be carefully scrutinized. But the vital question is always the good faith of the transaction. There is no other test. Fraud does not consist in mere intention, but in intention carried out by hurtful acts. Fraud or no fraud is generally a question of fact to be determined by all the circumstances of the case. Direct proof of positive fraud in the various kinds of covenants alienations which we are to discuss is not, as we shall presently see, generally attainable, nor is it vitally essential. The fraudulent conspirators will not be prompted to proclaim their unlawful intentions from the housetops, or to summon disinterested parties as witnesses to their nefarious schemes. The transaction, like a crime, is generally consummated under cover of darkness, with the safeguards of secrecy thrown about it. Hence it must be scrutinized and judged by all the surrounding circumstances of the case. The evidence is almost always circumstantial. Nevertheless, though circumstantial, it produces conviction in the mind often of more force than direct testimony. In such cases, where fraud is an issue, the field of circumstances ought to be very wide. From the very nature of the case, it can rarely ever be proved otherwise than by circumstantial evidence. And if the facts and circumstances surrounding the case, and distinctly proven, are such as would lead a reasonable man to the conclusion that fraud in fact existed, this is all the proof which the law requires. It may be observed that there can be no fraud unless there exist claims and rights which can be delayed and hindered, and which, but for the fraudulent conveyance, could be asserted. The law takes no cognizance of fraudulent practices that injure no one. Fraud without injury will not furnish a cause of action. Unless these elements coexist, the courts are powerless to render any relief. SS 14. Restraints upon alienation. A conveyance as regards real property may be defined to be the transfer of the title of land from one person, or class of persons, to another, or as a deed which passes and conveys land from one man to another. The usual incident of property of every kind owned or possessed by persons sui juris is the power of alienation. Generally speaking, every man may in theory of law do what he pleases with that which is his own. Almost the sole remaining restraint upon the power of alienation of land is that which adjudges void conveyances of real property held adversely by a third party at the date of the conveyance. Statutes adjudging such conveyances void were originally introduced partly upon the theory that it would be dangerous to permit the transfer of disputed or fighting titles, lest powerful and influential persons might purchase and use such titles as a means of oppressing poor people. But these statutes are being rapidly abolished, circumvented, or ignored as impracticable and unnecessary in this country, and even this restraint upon alienation will soon be wholly superseded. The restriction which we are about to consider upon a debtor's power of alienation of property at the expense of his creditor is one that has existed from time immemorial, and which will not outlive its usefulness so long as people are dishonest or inclined to be generous before they are just. The claims of creditors, it may be observed, rest upon legal obligations higher than the demands of affection or generosity. Commendable as a response to these may be when no duties which the law declares paramount intervene. Creditors, as we have said, have an equitable interest for the payment of their claims in their debtor's property, or in the means he has of satisfying their demands, and there is in our jurisprudence a clear restraint upon the debtor's right of alienation, where it is attempted to be exercised for the purpose of hindering, delaying, or defrauding his creditors, or defeating their lawful right to subject his property by legal process to the satisfaction of their lawful demands. The cardinal principle running through all such cases is, that the property of the debtor shall not be diverted from the payment of his debts, to the injury of his creditors by means of the fraud. The law does not restrain a man's dominion over his own property so long as he acts with fairness and good faith, but it avoids all fraudulent alienations devised to secure property from the pursuit of his creditors. It is fraudulent to defeat them by a reservation of benefit to himself. It is equally fraudulent to defeat them by benefactions conferred upon others. The current of law, says Professor Gray, has for centuries been in favor of the removal of old restraints on alienation, in favor of the disallowance of new ones, and especially in favor of compelling a debtor to apply to his debts all property which he could use for himself or give at his pleasure to others. The legislatures and the courts have co-operated to this end. Family and ecclesiastical pride, natural dishonesty, and narrow precedents have been formidable obstacles to this movement, but its general success has been unmistakable. The debtor must devote all his property absolutely to the payment of his debts, reserve no control for himself, provide for no benefit to himself, other than what may result from the payment of his debts, impose no condition upon the right of the creditors to participate in the fund, authorize no delay on the part of the trustee. A debtor may be said to sustain two distinct relations to his property, that of owner and quasi-trustee for his creditors. As owner, he may contract debts to be satisfied out of his property, create liens upon it, and sell or give it to others at pleasure, and, as we shall presently see, so far as he is personally concerned, he will be bound by his own acts. The law, however, lays upon him an obligation to pay his debts, and in behalf of his creditors holds him to the exercise of good faith in all transactions relating to the fund upon which they necessarily depend for payment. The debtor, therefore, cannot be permitted to create fictitious debts, or to do any of the acts specified mollified to the prejudice of his creditors. SS 15. Fraudulent Conveyances, Characteristics and Classes. A fraudulent conveyance may be defined to be a conveyance the object, tendency or effect of which is to defraud another, or the intent of which is to avoid some duty or debt due by or incumbent upon the party making it. As was said by Lord Mansfield in Cadogan v. Kennett, the question in every case is whether the act done is a bona fide transaction, or whether it is a trick and contrivance to defeat creditors. The same test has been referred to as decisive by Mr. Justice Story and Chief Justice Marshall. As we shall presently see, to constitute such a disposition of property, three elements must concur. First, the thing disposed of must be of value, out of which the creditor could have realized all or a portion of his claim. Second, it must be transferred or disposed of by the debtor. And third, this must be done with intent to defraud. Stated in another form, in order to bring a case within the terms of the statute, there must exist a creditor to be defrauded, a debtor intending to defraud, and a conveyance of property which is appropriable by law to the payment of the debt due. Usually, to avoid the transaction, there must be some interest in the property left in the debtor, some reservation inconsistent with a true sale, or some hiding or cloaking of the surplus so as to cover it up for the benefit of the debtor or his family. Whether a conveyance be fraudulent or not as against creditors depends on whether it was made on good consideration and bona fide. It is not enough that it be on good consideration or bona fide, it must be both. If it be defective in either particular, though good between the parties and their representatives, it is voidable as to creditors. It has been observed that to avoid a fraudulent transfer, three things are necessary: fraud on the part of the vendor, fraud on the part of the vendee, and an injury to the party complaining. This, as we shall see, is too general a statement, for in certain cases of voluntary alienations, proof of actual participation in the fraud by the vendee is not essential to annul the transaction. Again, these covenant alienations with respect to the rights of the creditors, existing and subsequent in the character of the debtor's interest, are divisible into three classes: where a debtor conveys a title in fraud of creditors, where a person not indebted alienates property with the intention to defraud future creditors, where the property is paid for by the debtor, but the conveyance is taken in the name of a third party. Dillon, J., observed, any instrument is fraudulent which is a mere trick or sham contrivance, or which originates in bad motives or intentions, that is made and received for the purpose of warding off other creditors. In another case, this language is quoted, whether the contract be oral or in writing, whether executed by the parties with all the solemnities of deeds by seal and acknowledgement, whether in form of the judgment of a court, stamped with judicial sanction, or carried out by the device of a corporation organized with all the forms and requirements demanded by the statute in that regard. If it be contaminated with the vice of fraud, the law declares it to be a nullity. Deeds, obligations, contracts, judgments, and even corporate bodies may be the instruments through which parties may obtain the most unrighteous advantages. All such devices and instruments have been resorted to cover up fraud. But whenever the law is invoked, all such instruments are declared nullities. They are a perfect dead letter. The law looks upon them as if they had never been executed. They can never be justified or sanctified by any new shape or cover, by forms or recitals, by covenants or sanctions which the ingenuity, or skill, or genius of the rogue may devise. In a case before the Supreme Court of Maine, it is said that a fraudulent transfer, however perfect in form, is void as to creditors. As does 16. Fraudulent conveyances at common law, statutes declaratory. By the rules of the common law, all conveyances made in fraud of creditors were regarded as voidable at the instance and suit of such creditors. The famous Statutes of Elizabeth, to be presently considered, avoiding fraudulent conveyances, were merely declaratory of the common law. The same result would have been worked out without the aid of the statutes. The statutes were not necessary to this result, but are to be received when such transfers are brought in question only as a true and accurate declaration of the common law. Lord Coke comments on the word declare in the statute as showing that this was the case, and Lord Mansfield, in Cadogan v. Kennett, said that the principles and rules of the common law, as now universally known and understood, are so strong against fraud in every shape, that the common law would have attained every end proposed by the statutes 13 Eliz, C5 and 27 Eliz, C4, and Chancellor Kent asserted that the Statute of Elizabeth was only an affirmance of the principles of the common law. This feature of our jurisprudence is of the highest importance, and creditors are justified in invoking it in cases where it is sought to defeat their claims as not coming exactly within the precise wording of the statute avoiding a particular kind of transfer. The flexible principles of the common law supplement and support the technical framework of the statute, and constitute the deep and broad foundation upon which the creditor's rights are founded. The mere omission of a provision embracing goods, chattels, and things in action, from a section of the statute declaring void conveyances and assignments of estates or interests in land made with intent to hinder, delay, or defraud creditors, will not be construed to be a repeal of the common law rule which renders a conveyance of goods and chattels made with such intent fraudulent and void as to creditors. In Fox v. Hills, the statute concerning fraudulent conveyances was construed not to comprehend claims founded on tort, but it appearing that a voluntary deed had been given to avoid such a claim, the instrument was promptly adjudged void at common law as to the creditor. In Lillard v. Magi, which was a suit to set aside a conveyance at the instance of a creditor whose claim was a judgment for damages in an action of slander. The court said, fraud is one of the main pillars of the jurisdiction of the Court of Equity, and there is no question of its competency, prior to the statute, to give relief in a case of this sort. Now, as the statute is made in affirmance, not in derogation of the common law, it cannot have the effect of taking from a court of equity its jurisdiction, for it is a settled rule that an affirmative statute does not repeal the common law. The common law of England, says Roberts, abhors every species of covin and collusion. But being tender of presuming fraud from circumstances, statutes have been specially framed to suit the exigencies of the times, which are as fertile in the artifices of concealment as in the opportunities of deceit. It was the prevention and not the punishment of fraud in which the common law was defective. For there is no instrument or act which is not liable by the law of this country to be rendered absolutely void by clear and explicit evidence of fraudulent intention. So general, indeed, is the condemnation of all fraudulent acts by the law of England, that a fraudulent estate is said, in the masculine language of the books, to be no estate in the judgment of the law. These words are employed in Alabama, the right of the creditor to subject property of his debtor, fraudulently conveyed, is founded in that principle of the common law which enjoins integrity as a virtue paramount to generosity. SS 17. Covenants transfers of choses in action by the law of England before the American Revolution, as established by decisions of Fortescue, Mr. Lord Hardwicke, and Lord Northington. Fraudulent conveyances of choses in action, though not specified in the statute, were voidable equally with transfers of tangible assets. But from the nature of the subject matter, the remedy of the creditors must be sought in equity. Gray, C.J., in the opinion in Drake v. Rice, says, of the only case before our Revolution cited in the line argument for the claimant, we have but this brief note: a man, being much in debt, 6 hours before his decease gives £600 for the benefit of his younger children. This is not fraudulent as against creditors, though it would have been so of a real estate or chattel real. The report, having been published in 1740, cannot have been unknown to the eminent English judges who made the decisions already cited, and, as observed by Lord Redesdale, the book is anonymous and of not much authority. The opinions of the English and Irish courts of chancery since our Revolution, cited for the claimant, cannot outweigh the cases above referred to, as evidence of the law of England at the time of the separation of the colonies from the mother country. In the case at bar, it is agreed that the law of New York respecting fraudulent conveyances is the same as the common law, and the law of Massachusetts, and that by the law of New York choses in action, although they cannot be attached or levied upon, yet may, after execution issued on a judgment at law, be reached by proceedings before a magistrate in the nature of proceedings under the Poor Debtor Acts of this Commonwealth, and by the appointment of a receiver to take and dispose of the debtor's property. SS 18. Early statutes avoiding fraudulent conveyances. The widely known statute, 13 Eliz. C5, perpetuated by 29 Eliz. C5 was not by any means, as many suppose, the first legislative attempt to formulate and declare the principles of the common law on this subject, or to repress covenants transfers by statutory enactment. By 3 Hen. 7. C. 4. All deeds of gift of goods and chattels made or to be made of trust to the use of the person or persons that made the same deed of gift are declared void and of none effect. In the prior act of 50 Edward. 3. C6 reads as follows: divers people do give their tenements and chattels to their friends, by collusion to have the profits at their will, and after do flee to the franchise of Westminster, of St. Martin le Grand of London, or other such privileged places, and there do live a great time within high countenance of another man's goods and profits of the said tenements and chattels, till the said creditors shall be bound to take a small parcel of their debt, and release the remnant. It is ordained and assented, that if it be found that such gifts be so made by collusion, that the said creditors shall have execution of the said tenements and chattels as if no such gift had been made. The statute, 2 Rich. 2. Stat. 2. C. 3. Contained provisions on the same subject, and from its recitals was evidently framed to repress the hypocritical religious zeal of fraudulent debtors, and to furnish a method of substituted service of process. The quaint provisions of these early statutes show conclusively that fraudulent conveyances are not entirely the offspring of our modern civilization. Fraud, which the common law so greatly abhorred, was so much practiced by debtors upon creditors in early times as to attract the attention of Parliament and to constitute a subject of frequent legislation. These statutes, said Lord Mansfield, cannot receive too liberal a construction, or be too much extended in suppression of fraud. It may be observed in explanation of this early legislation against fraudulent transfers that these statutes were enacted to more clearly formulate the common law with a view to suppress voluntary conveyances and secret trusts made by debtors who had escaped arrest for debt, or avoided service of process by fleeing to sanctuaries or holy ground. The number of these conveyances, however, was comparatively small, and their appearance is said to have been spasmodic and premature, and far in advance of the time for their normal natural development. Sanctuaries, or cities of refuge for fraudulent and absconded debtors, do not seem to have been wholly abolished until during the reign of James I, and one such sanctuary, the noted White Friars, which flourished in the reign of that monarch, has been immortalized by Sir Walter Scott in his Fortunes of Nigel, SS 19, Statute 13 Eliz, C5, in its object. This statute was passed for the protection of creditors, and is the great model which has been reenacted in substance, or copied wherever Anglican law prevails. The leading object of the statute was to prevent those collusive transfers of the legal ownership which placed the property of a man indebted out of the reach of his bona fide creditors, and leave to him the beneficial enjoyment of that which ought in conscience to be open to their legal remedies. By its provisions all conveyances and dispositions of property, real or personal, made with the intention of defrauding creditors, are declared to be null and void as against the creditors. Mr. Reeves says that several acts had been formally passed on the subject of fraudulent conveyances, but none of them had gone so far as the statutes 13 Eliz and 27 Eliz to restrain these famed gifts. Mr. Justice Story observes that this statute 13 Eliz has been universally adopted in America as the basis of our jurisprudence upon the subject. It may be found and acted almost intact in many of our statute books, and is still popularly called the Statute of Elizabeth, just as statutory remedies for the trial of title to real property are known by the familiar title of ejectment. Professor Pomeroy says, the operative statute in England, which is also the basis of all legislation and judicial decision in the United States, is the celebrated Act 13 Eliz. C. 5. The general interpretation placed upon the Statute of Elizabeth is well illustrated in a recent case in Maine, in which the court say, we derived our law in relation to conveyances fraudulent as to creditors from the Stat. 13 Eliz. C5, which has been adopted here as common law. This statute, declaring that conveyances made with intent to delay, hinder, or defraud creditors, shall be deemed and taken to be clearly and utterly void, frustrate, and of none effect, has been invariably construed as plainly implying that they are valid as between the parties and their representatives, and can be avoided only by creditors on due proceedings, or their representatives, such as assignees in bankruptcy or insolvency of the grantor, and the executors or administrators of grantors since deceased whose estates have been declared insolvent, and notwithstanding the words utterly void, etc., applied to such conveyances, they are not, even as to creditors, void but voidable, and all the courts concur in holding that if the fraudulent grantee convey the premises to a bona fide purchaser for a valuable consideration before the creditor moves to impeach the original conveyance, the purchaser's title cannot be disturbed. SS 20, its interpretation and construction. Notwithstanding, says Mr. Roberts, these laws are greatly penal. The rule still holds of giving them an extended and liberal exposition. Statutes in suppression of deceit and Calvin should be equitably expounded, although they are highly penal. In McCulloch v. Hutchinson, Sargent, J. said, the statutes on this subject are liberally expounded for the protection of creditors, and to meet the schemes and devices by which a fair exterior may be given to that which is in reality collusive. The statute, says Allen, J. has always had a liberal interpretation for the prevention of frauds. The law loves honesty and fair dealing, and so construes liberally statutes to suppress frauds, as far as they annul the fraudulent transaction. As early as Twin's case, it was resolved that because fraud and deceit abound in these days more than in former times, All statutes made against fraud should be liberally and beneficially expounded to suppress the fraud. It may be suggested that in construing statutes to prevent frauds, suppress public wrongs, or effect a public good, objects which the law favors, there is a pressure toward a liberal interpretation. But if they also provide a penalty, which is a thing odious to the law, there is another pressure toward the strict rule. So the balance may be in equipoise, or the one scale or the other may preponderate, according to the special circumstances of the case, or the views of the particular judge. The provisions of the statute are considered to be so plain that he that runs may read. SS 21, Statute 27 Eliz. C. This statute was enacted in favor of purchasers, and renders void as against subsequent purchasers of the same land all conveyances, etc., made with the intention of defeating them, or containing a power of revocation. SS 22, Twins case. This celebrated case is the creditor's beacon light in suits to annul covenants transfers. The decision was promulgated in 1601, 30 years after the enactment of the Statute 13 Eliz. C5. Evidently covenants dispositions of property were at that time beginning to attract attention and become troublesome. For, as already shown, it was resolved that because fraud and deceit abound in these days more than in former times, all statutes made against fraud should be liberally and beneficially expounded to suppress the fraud. It appeared, in this case, that P was indebted to T in £400, and was indebted also to C in £200. C brought an action of debt against P, impending the writ P, being possessed of goods and chattels of the value of £300, secretly made a general deed of gift of all his goods and chattels, real and personal whatsoever, to T in satisfaction of his debt. Notwithstanding which P continued in possession of the goods, some of which he sold again, sheared the sheep, and marked them with his own mark. Afterwards C had judgment against P, and took out a fiery facies directed to the sheriff of Southampton, who, by force of the writ, came to levy upon the goods. Divers persons, by the command of T, resisted the sheriff by force, claiming the goods as the goods of T by virtue of the gift, and whether the gift, on the whole matter, was a good gift, or fraudulent and void within the 13 Eliz. C5 was the question. It was determined by the Lord Keeper of the Great Seal, by the Chief Justices, and by the whole Court of Star Chamber that the gift was fraudulent within the statute, and as the signs and marks of fraud, it was said by the court that the gift was general, without exception of the donor's apparel, or of anything of necessity. The donor continued in possession, and used the goods as his own, and by means thereof traded with others, and defrauded and deceived them. It was made in secret. It was made pending the writ. There was a trust between the parties, for the donor possessed all, and used them as his proper goods. And fraud is always apparelled and clad with a trust, and a trust is the cover of fraud. The deed expressed that the gift was made honestly, truly and bona fide, et clausula in consuda semper inducant suspicionem. This case is popularly regarded as the fountain from which our modern law as to fraudulent conveyances flows, and the profession frequently refer to and draw from it in preference to selecting from the myriad of precedents and single instances which financial crises and the greed of dishonest debtors have since called into being. The leading doctrine taught by this case has been practically superseded in England, but it still holds a prominent place in our jurisprudence. The exact point decided in Twins' case is that a conveyance by a debtor of tangible property, if actually fraudulent, is void as to existing creditors. The impression that the principles of this case are sufficient to meet the exigencies of our modern jurisprudence is clearly erroneous. Though Twins' case has been characterized as a wonderful decision, and amazement has been expressed that the question involved should have come up for adjudication at such an early period. Yet it must be conceded that the facts of the case were too restricted to enable the court to furnish rules sufficient to answer all the varying imperative demands of creditors at the present day. Since this great decision was rendered, its principles have been extended, as we shall presently see, to avoid covenant conveyances not only as to existing creditors, but in certain cases as to subsequent creditors, and even as to contingent subsequent creditors. So it has been held to embrace creditors who are suing the debtor for tort, as for slander, or assault and battery, or the misapplication of trust monies more than 15 years before the conveyance. The statutes are not limited in their operation by any Procrustean formula, so the doctrine of the case has been enlarged to cover transfers of intangible rights and choses in action, such as stocks, transfer of an annuity, of a policy of life insurance, of an equity of redemption, of certificates of stock, of a legacy, insurance premiums, and all mere choses in action. Even an allowance for support to a wife under a judgment for divorce may be reached by her creditors. Still, Twin's case has taken deep hold in our law, and the main principles that control the determination of the different phases of fraudulent conveyances can generally be traced to this parent root. That the case should at this late day be so widely cited and relied upon as conclusive proof that it embodies a forcible exposition of sound and necessary rules affecting covenant transfers, which neither lapse of time nor change in circumstances can supersede. The case attains the same relative prominence as a precedent in the authorities that is accorded to the Statute 13 Eliz. C5. As a model for modern legislative enactments. It seems indeed strange that so many evidences and badges of fraud, common with us now, should have concentrated in such an early case, and should have been so swiftly and skillfully detected and labeled. If the facts of this case are not partially fictitious, and there is little reason to credit the intimation that they are, then it follows that the methods and devices of the fraudulent debtor have undergone few alterations since this remarkable decision was promulgated.